Hello everybody, this is Dr. Cole, Sunday evening, October 17th, as we now enter week 10 of Con Law Political Science 3753 for the fall term. Everyone, we've been looking at due process of law. This week on the syllabus we have search and seizure. It's actually called obtaining evidence on the syllabus. Next week, freedom of speech. We'll finish the term by looking at freedom of speech, freedom of the press, freedom of religion, and equal protection under the 14th Amendment, which is largely about racial discrimination, to finish up the term. Now, we'll be launching a discussion really related to the material we looked at last week under due process of law. Now, this is some material that really grabbed the attention of my students over the past couple of years. It's an article from the Atlantic Monthly about the criminal justice system and its reliance on the institution of the plea bargain. The question for you to consider is, have we really neutralized the right to a fair trial before a jury of your peers because of the criminal justice system's reliance on plea bargains? Now, of course, the defendant supposedly agrees to a plea bargain, but arguably that could be an agreement that takes place under duress, with the threat of the possibility of a far more severe sentence if the defendant does not comply with the plea bargain. Due to the institution of the plea bargain, instead of a trial, your fate as the defendant may be determined by a meeting between a prosecutor and a public defender that may last, 30 seconds or a minute. What are we going to do with this defendant? And then the prosecutor will propose a deal, and perhaps the public defender, being pressed for time, will agree to that in sort of a snap judgment. So does that suffice to protect our constitutional rights? Some of my students really had their eyes opened as to how the criminal justice system works in this respect. But that really is related to the material that we had for due process of law last week. This week on the syllabus we have the class notes for lectures 17 and 18 on obtaining evidence or search and seizure, which raises any number of issues, especially with regard to exceptions to the warrant requirement. Now, much of your class notes will be taken up with the issue of exceptions to the warrant requirement. The 14th Amendment leaves it unclear as to whether a warrant is required in each and every case of a search. Pretty clearly it's not. There are certain requirements that must be met for a warrant when a warrant is required, but it's not always required. Perhaps the major exception to the warrant requirement would involve searches of automobiles, because the automobile is so portable, and the courts have given police discretion. Since the automobile is so easily moved, it often can be searched without a warrant. And you'll find that the powers of the police are quite sweeping with regard to searching an automobile without a warrant. Now, at the end of the notes for Lecture 17, I'd like you to pay close attention to the brief discussion of the 1968 Supreme Court decision in Terry v. Ohio. It was Terry v. Ohio that legitimized the practice of stop and frisk. Basically, it says that the standard of reasonable suspicion effectively takes the place of probable cause. And police in metropolitan areas have relied heavily on stop and frisk in recent years, and many people have come to believe that the people being stopped and frisked are being profiled. So the policy becomes a warrant, often for stopping and frisking people of color. And so it's a very, very sensitive issue. So do note at the very end of Lecture 17, you have a brief discussion of the 1968 decision in Terry v. Ohio, which really served to legitimize stop and frisk, which is a very sensitive political matter. So we'll be launching a discussion in a couple of days on that material about due process of law, the article from the Atlantic Monthly that concentrates on the workings of the prosecutor's office in Davidson County, Tennessee, Nashville. And it perhaps will open your eyes to some of the things that go on. After that, everybody, we have some quiz material related to the material that is on the syllabus for next week about freedom of speech. You'll have a couple of articles to read. First Amendment law with regard to freedom of speech is in something of a state of upheaval, public discussion at least, because of the changes that have been brought about by technology. Questions have been raised as to actually as to how extensive a freedom of speech we ought to grant, given the opportunities to spread what might be considered malicious or conspiratorial speech through social media, technology, and the internet. Somebody called it cheap speech. In fact, you've got an article about the matter of so-called cheap speech. What cheap speech means is there really are no gatekeepers and few barriers to entry with regard to speech these days. The implications for you might be that if you were to be libeled, if you feel that you would be libeled, it might be hard to win a judgment from a TV network or the New York Times, but those entities have the resources to pay you a judgment if it is found that they libeled you. That's not necessarily the case at all for somebody who might libel you with a quick tweet on the Twitter platform or a Facebook post. So it's really something of a wild west out there when it comes to derogatory, inflammatory, or conspiratorial speech, and some people think that this raises questions with regard to First Amendment law. So you want to take a look at that material that you should have in an announcement and an email that I've sent out. That'll be the material for, I believe, what will be quiz number 5 next week. Not this week, but next week when we have freedom of speech on the syllabus. We'll have a discussion beginning later this week based on that article from the Atlantic Monthly. And then once that discussion ends, a day or two after that, we'll have quiz 5 related to freedom of speech issues and First Amendment issues raised by new technology. So that's quite a bit for you to do, reaching back to last week through this week and next week. So you'll want to get started looking at some of that material right away. So we'll be launching a discussion later this week, and once the discussion is over, we'll have a quiz next week, and that'll give you enough to keep your hands full. So we hope you will get down to business and get started working on that, taking a look at it, and we will speak to you again about a week from now at this time. Take it easy.